Good morning, everyone. My name is Mavanwi Warwick, EGM for Regulatory Compliance Global and Executive Sponsor for our Rule of Law projects at LexisNexis. Before we get started today, please note this session is being live captioned by AI Media to make sure that the content is accessible for those with vision or learning difficulties. You can also scroll back to read previous text if you've missed something, and you can read the real-time captions as a full page of text as well. A transcript will be available following the session upon request. For the live transcription, please see the link in the chat. If you would like to submit questions as we go along, please use the Q&A rather than the comment function, and we'll hopefully get to them during our panel section today. So I'll begin this very special event by acknowledging the traditional custodians of the land on which this meeting takes place and pay my respects to elders past, present and emerging here in the land of the Wallumattagal clan where I am and the land on which you stand. I would like to welcome everyone to this panel discussion on the implications for legal and compliance professionals of the final report for the Human Rights and Technology Project. The report was recently presented in Parliament after 291 consultation participants, 725 conference presentations and 84 national survey participants, as well as 4 papers released over the last 3 years. And now to our panel. Her Excellency, the Honourable Margaret Beazley ACQC, as the Governor of New South Wales, needs little introduction, but I would like to highlight her years of distinguished service to the law, and particularly as a mentor of young women lawyers. Her career is one of many firsts. As Judge of the Federal Court, the first woman to sit exclusively on that court, and the first woman appointed to the New South Wales Court of Appeal and then its president. We are delighted to be able to discuss with her this world first project. Ed Santow has been Human Rights Commissioner at the Australian Human Rights Commission since 2016 and leads the Commission's work on refugees and migration, human rights issues affecting LGBTI people, counter-terrorism and national security, freedom of expression, and implementing the optional protocol to the Convention Against Torture. It is through Ed's vision and leadership of the Human Rights and Technology Project that we're all here today. Peter Leonard, as founding partner of Gilbert and Tobin, Professor of Practice, Management and Governance and Information Systems and Technology Management at UNSW and Principal for Data Synergies, was an obvious and important choice for the expert reference group for the Human Rights and Technology Project. He's also been selected to lead and participate in many committees, including the New South Wales Government's AI Advisory Committee. Uma Karana, an experienced technology procurement and regulatory compliance lawyer who provides specialist legal advice on the application of privacy and surveillance laws to new technology initiatives, including implementation of software solutions incorporating algorithms and machine learning functionality, biometric and facial recognition, the Internet of Things, and various technologies which incorporate optical, audio, or tracking surveillance. So welcome to our panel, and we'll begin by hearing from Ed on the key issues raised by the report, as well as a summary of findings. Thanks, Ed.
Thank you very much, Mafanwi, for that warm introduction. It's a great pleasure to beam in to all of you from Gadigal land, where I am, and I pay tribute to the elders past, present and emerging of this land that I'm on. I also want to acknowledge the fact that Her Excellency, the Honourable Margaret Beazley, Peter Leonard and Mafanwi have all been members of our expert reference group. Uma is someone whose expertise and kindness I've kind of lent on in wearing a number of hats over the years. So it's wonderful to have this group of people together. In a moment, I'm going to share my screen and go through a few slides. For anyone who has difficulty seeing, I just assure you that I will speak to each slide so you won't lose any information that way. But I want to start by giving a little bit of context. And the most important piece of context is that, you know, when we talk about human rights and technology, we're particularly talking about artificial intelligence. And we've seen this huge, almost exponential rise in the development and use of artificial intelligence, or AI, over the last couple of decades. And the landscape into which that rise of AI has come is really interesting, because it's often said that AI has come to the fore in a digital Wild West. In other words, in unregulated territory. And we, throughout our project, really looked deeply at that kind of core proposition. And I'm going to choose my language very carefully here, and particularly my grammar, because what we found is that AI raises a number of legal and indeed human rights issues. And while the law has not been consistently and rigorously enforced in some areas, that's not because there is no law. And so one of the core recommendations from our project is to make sure that the law is more effectively enforced or applied, to make sure that people are kept safe in the use and development of artificial intelligence. So that's a bit of context. I actually want to start with some of the things that we heard. So we heard loud and clear from the Australian public in a range of ways. And since our report was tabled in Parliament, there's also been some further opinion polling that's been done that kind of bears out some of what we heard. So I'm just going to put a couple of those opinion polling results on the screen now. The first shows that whether AI is being used by government or by the private sector, people are deeply concerned about that use of AI in decisions that affect them. So 73% by companies and 70% when it's government using AI. So very, very similar figures. So in other words, I guess what I'm saying is that people really have relatively low levels of trust when it comes to the use of AI. And so that's something we need to heed. In particular, we looked at human oversight and accountability when government uses AI and automation. And we did that because obviously government makes very important decisions that affect people in the most profound ways. And also in, I guess, the aftermath of some more controversial uses of AI. Perhaps the best known one here in Australia was the automated system of debt recovery for Centrelink recipients, which came to be known as Robo Debt. What the recent opinion polling that Essential did showed was that there's really strong community support for better accountability mechanisms when it comes to the use of AI, especially by government. So I draw to your attention there, 62% supported that proposition, only 12% were opposed. So a significant number, about a quarter, 26% of people who either were unsure or another opposed or supported, which shows that this is, I guess, very new to many people, myself included. So what does all of this mean for us, especially those of us who are lawyers or working in compliance? Well, when you boil down our recommendations, there were three main things that we said about what needs to change, and they all relate to accountability. When AI is used to make a decision that affects someone, it could be anything from a welfare decision, it could be a decision about employment. We know that AI is increasingly being used to help recruit people. It's often used in customer acquisition or in deciding whether someone will get a bank loan. In all of those scenarios, accountability is critically important to make sure that AI is always used in ways that comply with people's basic human rights and their basic rights as consumers. So what I've got on the screen here is the sort of three main areas in which we think accountability needs to be enhanced. The first is transparency, and what in tech speak has become known as explainability. So I just want to briefly explain what I mean by that. So by transparency, people told us again and again, they're not opposed to the use of AI in decision making, either by government or by the private sector, but they want to know when AI is being used. They want to know when they're subjected to a decision that has AI built into it, even if it's a human who ultimately is responsible for the decision and conveys the decision. They also want to know the reasons for the decision. So I'm an old admin law person, and so I would tend to use that term, reasons for decision. In tech speak, it's called explainability. It's basically the same thing. People want to know that when a decision is made, that there are reasons for that decision. They want to know what those core reasons are. To put it in other terms, people don't want the situation where they get a decision which they're disappointed about, and they're left with this unsettling feeling that maybe the decision was unfair. Maybe, let's say, the decision was against them because of something they couldn't control, like their race, their sex, their gender, the fact that they have a disability, their age, whatever it happens to be. They want to be able to interrogate the decision and be confident that the decision was fair and lawful. And so that's where that concept of explainability comes in. The second kind of cluster of recommendations really goes to the effective legal protections. So I've alluded to one of the core areas of concern that was raised with us, which was fairness and specifically equality or non-discrimination. So people want to be very confident that when a decision is made that uses AI, that those laws that are designed to protect us, like anti-discrimination laws, are effectively applied. And that really goes back to that idea of the digital Wild West. If you have laws that are on the books that theoretically are applicable however a decision is made, but they're not being as effectively and routinely applied in a particular area of decision making, like decisions using AI, then you've got a problem. And so regulators, including the Human Rights Commission and really the entire regulatory ecosystem, I guess, needs to build its capacity in understanding how AI is changing decision making to ensure that people's basic rights are upheld. And so that means, I would say that's true if you're a lawyer, whichever side of legal practice you're on. So if you're a plaintiff lawyer, then obviously to ensure that your client's rights are protected, you need to understand this better. But also if you tend to be a lawyer who acts for government or for companies in defence, on the defence side, then this is also important for you, not least so that you can give your clients good advice so that they can develop systems that help them to make decisions that use AI in ways that will be fair, accountable, and accurate. And that was very important. And then finally, the mechanisms of review need to be effective when it comes to the use of AI. One of the core concerns that people raised again and again when it came to what came to be known as Robo Debt was they wanted to know who they could go to in order to challenge the decision. And if that is unclear, if all, to use the kind of modern parlance, if all you get is the answer computer says no and no way of challenging a decision, then that's a serious problem. So we need to make sure, particularly when it comes to decisions by government, that is administrative decisions, that the appeal pathways, the review pathways are crystal clear and they're effective. And so people aren't in any way disadvantaged because of the technology that is used to make a decision. So I've just got a couple more minutes before I hand back to Mfanwi, which really just allows me to go through two last things. The first is to just kind of emphasize one of the issues that I alluded to before, which is of greatest concern to people, and that is the risk of discrimination. In the tech space, there's a $3 term for this, which is algorithmic bias. Essentially, that's where an algorithm may be trained on many decades, sometimes, of past decisions, and it learns from those previous decisions. That's how a machine learning system operates. Sometimes those older decisions will, in a sense, embody historical problems, including prejudice and even unlawful discrimination. And so unless a company or a government agency is really mindful in how they deploy those decision-making systems that use that historical data or rely on that historical data, you risk doing what I'm kind of a bit melodramatically referring to here is awakening the zombie. So we've seen, particularly overseas, in decision making on loans or in the credit area, how sort of significant progress that has been made in gender equality can sometimes be set back if decision-making systems over-rely on these systems, these older decisions, which may, as I say, encapsulate that historical bias. And so the last thing I'll leave you with is I've really given more of a taste than anything else of some of the key themes that we've gone in quite deeply into in our final report on human rights and technology. The report itself is available at tech.humanrights.gov.au. It's like any Human Rights Commission report, it's quite detailed, which is code for saying it's reasonably long. It's been over 200 pages. We're conscious that particularly if you're in practice, either legal practice or you have a busy professional life and you may just want to get a quick snapshot, that you may not have the time to go into all of that depth. So we've also put on that website a number of summaries and quick kind of primers on some of the issues that I've raised today, as well as a number of other issues that hopefully we'll be able to cover in today's session. So with that, I'm going to stop sharing my screen and hand back to Mfanwi.
Oh, thanks very much, Ed. And I have to say, I've shared this with a few people myself, and someone actually said I couldn't resist reading the whole report. So I think that's a great endorsement of the work that you've done, not only informative, but interesting. So I'll start with my questions to the panel, start with Her Excellency. Governor Beazley, you often provide comfort to people in the aftermath of terrible disasters like bushfires, and I'm sure the pandemic as well. We've seen technology help us get us through a crisis like telehealth being used during the pandemic. Do you think there are also some risks that our reliance on this sort of technology continues after the end of the crisis?
Oh, I'm sure there are risks. I think that's almost the essence of the whole report. I'll just make 3 or 4 points, if I may. You mentioned the bushfires. Now, it was interesting with bushfires that these days, so much of weather reporting, in fact, all weather reporting is really remote. It's really part of the technology that you're talking about. It all sits in satellites up in the geostationary orbit. Now, what we were being told when we were going around to bushfire areas was that these fireys, as we call them, the firefighters, who have been on the ground for 20 to 30 years and said bushfires follow a pattern, and in the 2019-2020 bushfires, they didn't follow any pattern. They could not tell how they were going to run, where they were going to run to, how quickly they were going to come, where the big wind surges were going to come from. And that seemed to have been a function of drought because it was so dry, and it was a function of probably fuel load. And I know there's been some controversy around that. So sometimes technology doesn't have all the answers, particularly. And one other complaint that we heard is that many decisions were made on bushfire modelling. And if the weather pattern was just different, caused by those circumstances to which I've just referred, then the modelling actually wasn't helped because it was being made on old information, if I can put it that way. And the view was that there was a suspicion that things may not get better unless something really amazing was done in terms of overall drought and land care. So that's just one comment, which just showed you may not have actually worked. Telehealth has to be seen as transformative. There's absolutely no doubt about that. In a tiny little town way out in what they call the corner country, out in the border of New South Wales, South Australia and Queensland, there's a tiny little town called Louth, where they have a clinic where the telehealth consultation room can be remotely opened from Broken Hill. The patient can be let in. The patient can then be instructed how to use the equipment which is there. and it's all fed back. Now that is really quite extraordinary. The patient has to be, you know, sort of reasonable health to be able to do that, but still absolutely transformative. But the medical services out there, and every town that we go to just says, where are the doctors? We need the doctors. We cannot lose that on-ground clinical expertise which is required for the good health of an organisation. And if we hand it all over to telehealth, that is going to be lost, and I think that will be a detriment. So this is a classic example of a transformative technology which has a place that can't be a replace, if I put it that way. That's the message that I heard. Another item was in relation to insurance. Now, insurance is one area where technology does make decisions, so that if too many claims come from a particular area, from a particular suburb, etc., then that starts impacting on premiums, for example. Absolutely hit the nail on the head with the floods up in Port Macquarie, where we were being told there were many, many people uninsured because it is a flood-prone area, because insurance premiums had hit $30,000 a year, and that is just unsustainable for you know, sort of people on other than a very high professional income, and even then it's a it's a pretty big hit. So that is very serious. That is a very, very serious issue for that particular area. Education is another area where, in remote communities, technology is transformative. It allows students in very small clumps, but of all different ages, to have just one teacher and being able to supervise them, because they're doing their telemaths and things like that, and the kids are loving it. It's just fantastic. But one of the things that I'll raise, and this leads into really the last point I want to make, if that's the way education is significantly going to go, what happens to human interaction? What happens to the ability to learn about other people? You can call to be empathetic, you can talk about that, but even to you know, sort of understand how people think and operate and react, and how they might react to your actions and things like that. Very, very human circumstances, which we all grew up with in as you got pushed over in the playground. But if that's not going to happen, I think that is really going to be a huge change in society. And added to that is one of the huge complaints we hear is those people in the city, they make all these decisions from us, remoteness from central decision making, that will increase, I think. And yet the need to be listened to and acknowledged is at the heart of every regional town we go to, big ones and little ones. We need to be listened to and acknowledged. And I don't know, I don't think AI is very good at listening yet, is it? Let me leave my comments at that, because you know they're very observational comments, and let me hand you back to the real experts in this field.
Well, thank you so much, Governor. You've given us, even in this very first question, a lot of things to think about. And if I could make one light comment, as the parent of children who are currently undergoing online learning, I cannot wait for human interaction at school to be re-established. But I think, you know, your comments about placing technology rather than replacing human interaction, and also we know from the many studies that have been done that there are certain benefits that technology can bring. But the one thing that we should all take comfort from is that it is very unlikely to replace the strength that we have in human interaction and the skills that we've developed over time. I think that's a really great point, and probably leads really well, hopefully, to the question that I'm going to ask Peter, which, Peter, you know, because we've been involved in this for some years now, definitely a highlight that technology brings benefits and risks, as well as highlighted by the Governor. What are particular examples of this dichotomy that you see in your work, and how do you think we can work together to ensure that the benefits are maximised?
Thanks, Mafoni, and thank you, Your Excellency. Look, just to pick up on one of Her Excellency's last points around insurance, it's actually a good example to work from, because one of the things that advanced data analytics, of which AI is one manifestation, enable is much better, more granular targeting and individuation of individuals within a group. So in the insurance sphere, that enables insurers to tailor the premium to suit the risk profile of a particular individual or asset. Now, that is a positive in the sense that you get to full marginal pricing and as a result, much more efficient insurance pricing, but it also can undermine the very basis on which insurance is constructed, which is collectivization of risk and potentially community rating. So AI, almost invariably with AI, when you look at positive examples and ability to improve markets or make society better, there is also the downside, the dark side to the cloud that has to be taken into account. And then you get into a discussion as to who it is who should be responsible for managing that risk, whether there's a need for regulatory intervention, whether organisations deploying AI adequately understand those risks and are willing to address them, or whether we need to create new incentive frameworks, new penalties, new sticks to control a market. And really, I think one of the best examples of it is to talk about so-called personalisation and its flip side, which is actually another word meaning the same thing, of individuation. And I like to start from the phrase that I don't need to know who you are if I know enough about your characteristics, your attributes, that I know whether and why to treat you differently from somebody else who I also don't know who they are. So if I can differentiate you from others, I can either bring you benefits, benign differentiation, individuation, personalization, or I can deny you benefits. And examples of benign individuation, a single point of entry in dealing with government, so you don't have to give government your details every time you deal with a different part of government. Tell me once, pre-population of forms, so you don't have to fill out the form in detail every time because the form's pre-populated by what it knows before. Targeting of assistance, or indeed targeting of enforcement. And a really good example in New South Wales government is the Department of Revenue using algorithms to work out whether to pursue enforcement action against non-payees of fines. And they use algorithms to work out who it is that is unlikely, or the characteristics of people that are unlikely to be able to pay, and in relation to whom enforcement action would just create further pain for those individuals. So there's a really good example of AI as a benign tool as used by government to differentiate and determine not to bring enforcement action against individuals who simply do not have the capability to pay. Then we have the many examples of not so benign differentiation, unfair discrimination, charging more, making an unreasonable demand, using AI as a tool to work out who to bring enforcement proceedings against in a way that is excessive surveillance that should not be permitted, targeted political advertising, and so on. And the Human Rights Commission's report examines many of those things. So I just finish by saying that individuation always requires, or should require, an organisation to stop and think, is the personalisation that the organisation is planning to do through the use of advanced data analytics or AI fair to an affected individual? Is it adverse to their interests? And is it, to use words that the Commission uses, respectful of an individual's dignity, taking into account their disabilities and limitations, and is it socially responsible? Now, all of those things might sound a little bit airy-fairy and rights-based, but increasingly we are finding that unless organisations think that way, they will deploy business models which are not sustainable in the longer term, because they will be held to account once people determine that what they are doing is socially reprehensible. So if you want sustainable business models, you do need to stray into the fields of consideration of individual rights and social responsibility, because otherwise you'll be building a business on a business model that won't be sustainable in the future. Back to you, Mafuni. Oh, well, we got
it looks like, yeah, it looks to me like...
Have we lost Mafuni? Goodness me. If we've lost our
might...
chair, we could really run rampant here, Ed. We could get quite out of control.
This is quite exciting. I'm happy to... I know the question that Mafuni was planning to pose to Uma. So while we're waiting for Mafuni to come back, I might...
Keep going, Ed. You asked the question.
Okay, I can. Yeah, I'm going to ask Uma the question. Uma, you've worked with a range of people across both the public and the private sector, as well as for the regulator during your time at ASIC. Within our wide-ranging report from the Commission, what are some of the recommendations that you think will resonate most with your clients?
Thank you. Thank you, Ed. Yeah, look, it is a very wide-ranging report, and can I just say congratulations to everyone on the panel who's been involved, and Mavumwe as well, who's obviously dropped off at the moment. But it's been really exciting actually to watch the progress of the report, and I've been following it over a number of years, and I know that it's clear that a lot of work's gone into it by everyone, I think, at the Commission, but especially yourselves. And it's actually really exciting for me working in this area to see Australia taking the lead in some of these issues and taking on these debates, because I think these are things that we can clearly see liberal democracies across the world are grappling with. And certainly from my perspective, and Peter's made this point as well, there are there is an increasing trend working as a technology lawyer. Over probably the last 5 years, there's a real sort of drive towards the adoption of solutions which have some element of AI, solutions that allow for the greater use of surveillance, solutions that rely on the use of biometrics and facial recognition, and all of these are things that have been picked up and are addressed in the report. What I'd say is, when working at the coalface and advising clients in this area, obviously my focus is particularly in privacy and surveillance law, and it is actually really difficult for clients sometimes to grapple with what the actual black letter law requirements are. And I would say almost without exception, and we work predominantly for customers rather than suppliers, but predominantly people are coming to us for support, want to do the right thing. They want to make sure they're complying with the law, but also they want to acquire solutions that, number one, they work, they're accurate, They don't want to spend money on something that doesn't work or can't be relied upon. They're looking, you know, particularly government clients have an obligation to provide value for money. They're looking at the ways in which those solutions meet their obligations under procurement guidelines. And there is a very, it is a very patchwork sort of existing framework that exists. So while there are black letter law prohibitions in relation to discrimination and which protect interference against the rights of privacy, there is also a very inconsistent framework where, for example, surveillance laws can vary from state to state. A New South Wales government client may be acquiring a solution, they're subject to a state-based Privacy Act, and the provider of that solution is subject to the Commonwealth Privacy Act in Australia, and so those obligations are inconsistent there. So I think from my perspective, the really key recommendations here are around regulation and implementing a regulatory sandbox, as you've called it, and having a complementary set of tools which can work together to really ensure that there is collective responsibility here. So when we know that when regulation works well, it's in a sort of almost like a pyramid shape where the majority of the impact needs to be at the bottom level, where there's a minimum amount of intervention from a regulator, there's a voluntary standard, there's education, people are well aware of what their obligations are, and the majority of them want to do the right thing. And the regulator is then able to really focus its efforts and its limited, often, resources at the top of the pyramid and on participants who are less willing to do the right thing. But for that to work, there does need to be some of the things that have been recommended in the report. So things like having certification schemes and having voluntary standards, I think, are crucial, because that ensures that when a customer is going to market for a solution, they can actually compare like for like, and they can test the accuracy and the reliability of a solution before they buy it, essentially. And in the current environment, that's not always possible, or it's extremely difficult. So, including because we have legislation sometimes that's been drafted last century, which sounds like a long time ago, more than 20 years old, and it's not technology neutral, or it has a very strict prohibition which allows no scope for innovation, and it does not have any technology neutral application. So if you cannot use it full stop, then there's no way to test it, there's no way to pilot it, even if there would be an exemption, for example, in relation to law enforcement, which would allow you to use it in practice. So these are the types of issues that can be very difficult to navigate. And I think that from my perspective, that's clear that the key recommendation that the report makes, and which I think will be essential, and I'm so pleased to see us kind of drawing a line here and saying, let's move forward from here together, but let's do it with our eyes wide open, looking at the issues, understanding where we're going, and rather than a piecemeal approach in terms of black letter law, but also, you know, even today I've seen a media announcement about, I think it's Telstra, developing their own code of practice. That will continue to happen, and there are some really good corporate players taking a really active role here. But when that does happen, everyone's moving in a different direction, and there's not necessarily a cohesive approach. So that's, from my perspective, you know, really the key focus for me. And as I think Mvanwi has also said earlier, I have also, you know, have clients who are definitely very engaged with this report already, which is, I think, hopefully a positive, good sign for you.
I might just see, Mvanwi, if you're right to jump in again now.
I really hope so. I said before the call started, you know, it's always embarrassing when you're talking about technology and then you have issues. So hopefully that's just provided a piece of light entertainment in this complex subject that we're talking about. So I did have a question for you, Ed, and one thing that I'm really interested in, which I think all the speakers have touched on is how we balance responsible innovation with the protection of human rights. How do we consider concepts relating to the commercial viability of Australia as an innovation hub, or for individual organisations in their business models, as Peter was talking about, as well as the public trust required to achieve this here. So how do you feel this balance has been met? And if human rights are not, if human rights are indivisible, are their recommendations indivisible? Is there one that's more important than the other? How can we take this forward?
And that last part is very difficult, like trying to choose between, you know, your children, which is your favorite. I think you're asking a really important question though. And it also goes to one of the themes in the Q&A that's coming through from, I'm specifically referring to Mark Staples' question, that the promise of AI is better decision-making. And just to unpack what we mean by better, we mean by that more rational decision-making. So decision-making that better is able to kind of sift through relevant information, data, including personal information, but also other data, and bring that to bear on whatever the question is that we're trying to answer. But also more efficient decision-making as well. We know that process, that sifting process, gathering together all of the relevant evidence can take a lot of time, and it can take, you know, a lot of resources. So there are a range of reasons that, you know, we'll be able to kind of answer questions, solve problems more quickly, better. That's at the heart of the promise of AI. And it's not untrue. I'm saying that in a very, you know, lawyerly double negative. It is true, right? Like there are a number of specific areas where decision-making is truly being improved because of AI. And I guess what we're trying to sift out is where AI is already being used well, shine a light on that, try to get to the bottom of what it is about those areas of decision-making where AI is being used well, and then equally shine a light on areas where improvement is needed. So it tends to be that in areas where there's a binary answer, it's either right or it's wrong, AI can be particularly good. You know, for example, we know to choose an area where I'm particularly interested just personally, we know that in some areas of science, like you know, diagnosing skin cancer, the best AI is more accurate and thousands of times faster than the best, most accurate, most experienced human doctor. That's amazing, right? And that's largely because melanoma is either this particular grade or it's not. There's no exercise of judgment, which brings me to where AI struggles more. And that's where, you know, it's exercising quintessential human judgment. And that's the areas where we need to be much more cautious about whether we're there yet, and whether we need more boundaries around it to make sure that that can be protected. The last thing I'd say is that in some areas of human rights, you know, the protection of human rights can kind of go counter to good kind of business, economic activity. I think what we see here is that if you make better decisions, if you've got that at the real heart and accuracy really matters to you, then on the whole, you're going to be better upholding human rights. So a bank that wrongly thinks that a woman is going to be a bad customer because of that problem I alluded to at the start, I care about that because it's a human rights violation for a female customer who gets knocked back unfairly. The bank should care about it for that reason, but they should also care about it for another reason, and that's because they've lost a good customer. You know, if they simply haven't updated the data on which they're training their systems, then that's a problem for the bank for that reason as well. While I've got the microphone, oh, sorry, go ahead, Peter.
I just wanted to add another point to Ed's, picking up on what Ed was saying, that AI generally should be a tool for better and more efficient decision making. It is also important, though, to bear in mind that AI is different to, for example, a word processor. So the word processor means that, you know, when you press the E on your keyboard, an E should appear in your word processing package. But AI is often, and probably usually, about the drawing of inferences. And inferences, by definition, Daniel Kahneman makes this point very well, are wrong in some cases. So if I draw an inference that is 95% right, I'm going to be wrong in 5% of cases. And you might be one of those 5% of cases in relation to whom the AI is wrong. That doesn't necessarily mean the AI is not reliable, but what it does mean is that humans have to think about how and where the AI is reliable. And that was the point I wanted to come in and say, you always need to think about AI as a component in decision making and how it fits together with humans, and whether humans are becoming overly reliant on the reliability or accuracy of the AI. And that makes it a really tricky thing. And it's what makes it very different from buying other forms of technology. And indeed, one of the problems that you have when we talk about AI is people immediately want to talk about the technology that is AI rather than the decision-making process within which AI is usually deployed, and how that process change and new risks are introduced by virtue of the introduction of that component. So it's a very sort of tricky and interesting area, and one, as a result, where it is easy for organisations to misframe the problem and not see issues until after they arise.
Well, I think that you've introduced the magic word risk there, Peter, which is something that I was hoping to talk about today. So especially in the terms of compliance professionals, who I know a number of whom were going to join the call today. So I've been talking to a few about the recommendations, and what they're all, I have to use the word relieved about, is that they actually acknowledge the challenges as well as the opportunities that compliance teams currently face to enable them to do what they do well, which is make it easy for all three lines of defence to achieve compliant, ethical and commercial outcomes. So the existing complexity, the number of legislative instruments that currently apply, thousands of changes that happen every year, frameworks are constantly having to be reviewed and updated. We're also seeing additional pressure from overseas regulators who are not shy about handing out multi-million-dollar fines. So by leveraging existing regulatory instruments and agencies, and I think Ed used the phrase modest reforms, the new recommendations will only build upon these existing internal resources and processes rather than add to them exponentially. And one example of that is the Human Rights Impact Assessment tool. And I know some organisations are using them. Some people might not have heard of this or might not be familiar with them, but I think as I describe it, you might find it strangely familiar, especially if you're familiar with our ISO standards. So taking the Danish Institute for Human Rights example, they have steps around planning and scoping, analysing impact, mitigating impact, reporting and evaluation. And these are very similar to the ISO compliance framework of establish, develop, implement, maintain, evaluate and improve. And I highlight the improvement because that's obviously key to what we're talking about today, due to the intersection of acceleration of both the technology and the regulatory change. And ISO 37301 is really interesting, I think, is obviously it's part of the self-regulation, co-regulation framework that was referring to, giving everyone, though, a standard that has international status, very appropriate when we're talking about regulation of technologies which have no physical boundaries. And like all the ISOs, it's linked to the UN Sustainable Development Goals, in this case, SDGs 8, 11 and 16, which, as we've already talked about, relate to both human rights and sustainable development. And I think also the utilisation of standards should be consideration in terms of public trust required to support the AI-powered products. And by support, I mean actually use them so we can get all the efficiency and human rights benefits that we know we can from these new technologies. So the trust can come from a number of aspects relating to the standards. As was highlighted by Rosemary Caius in the accessibility webinar, the process of creating ISOs is robust and not subject to negotiation, my air quotes, in the way other instruments might be. And particularly ISO 37301 status as a certifiable standard is something that's being increasingly recognised as a way to create confidence across regulators, employees, shareholders, the general public, and of course the courts as well. The standard does note that the courts will take into consideration the organisation's commitment to compliance, such as having a compliance management system in place when determining an appropriate penalty for breaches, which is certainly a very good reason for implementing the standard. And I think another way of getting that trust is the consultation element that's common to the report, the Human Rights Impact Assessment and ISO, which is consultation across all affected stakeholders or interested parties. And the level of consultation is not only obviously the right thing to do, but it's actually the commercially sensible thing to do, I would suggest, especially in product management. You can have a healthier cost base because you avoid expenses like retrofitting a product that didn't meet regulatory or community expectations. You avoid fines or costs arising from enforceable undertakings, and of course, that plain old reputational damage. On the flip side, having that diverse group at the start of your consultation process will mean that the product is actually suitable for the widest possible market, which gets you good top line growth. So I'm thinking it's actually, you know, from a profit point of view, a very sensible way to proceed. So, you know, when people are reading through the 200 pages or the overview and thinking about how to make the recommendations part of their compliance framework and achieve positive outcomes from a regulatory, human rights or commercial perspective, hopefully all three, one area of focus could be on ensuring you always have the right people in the room as part of your consultation process. And one way that I think this can be easily done is have a look at your inclusion and diversity policy. Make sure your recruitment process maximises participation from the whole population, and your talent retention process enables equal contribution from everyone to succeed in your organisational goals. Again, I think this has commercial benefits, not only from having a team that genuinely represents your customer base, but it's also easier to avoid any potential issues impacting the human rights of individuals or groups if you already have those people with lived experiences when discussing developing any new technology or making decisions about implementing it in your organisation. So because, as I expected, we have such a lively, expert and engaged panel, we've got a few minutes for questions, Ed, but I'm not sure how you'd like to proceed from here.
Yeah, I'll try and cover a few and might group a couple of themes. But just to pick up on a point that you made, Mufamwe, about human rights impact assessments, and I think your organisation has shown how that can be done in a really practical way through your obligations registers. That's a really good way of making sure that you're considering all of the relevant issues effectively and in a practical way that makes sense. I have a cough that is not COVID.
The disclaimer that's ubiquitous now.
Yeah, that's right. One of there have been a number of questions, and Your Excellency, the Governor has, I guess, sparked some, I think, real interest with the approach that you take. And if I can sort of summarise, I guess, a couple of themes arising from the questions, and then put it back to you. I guess what you've said is we need to be more mindful about when and how we use new technology. It can be enormously useful and beneficial, and so we can sort of see that in place. But we also need to ask ourselves the question whether, if it's beneficial and useful in one context, will it remain beneficial and useful in another, or after a particular emergency has passed, in the example of telehealth that you gave. I guess one of the key questions is whether that should be something that should be taken into account in how we legislate in this area. And if so, how do we do that? Do you have any reflections on that, Your Excellency?
Am I there? Yes.
Yep, you're there.
I don't see telehealth as being following a legislative model. During COVID, we were talking to one of the major cancer health institutes and asking them how they were coping. And it's a hospital-based institute, and with COVID and cancer patients with very compromised immune systems, what were they doing? And they recognized very quickly, and you think it would be obvious, but still people operate professionally in a particular way, and sometimes they need to make the adjustment, that it really became horses for courses. There were certain things where in their field of operation, things worked fabulously, like the prescription, the update of the prescription. So the original clinical assessment had already been done, and the treatment that was needed wasn't on-site hospital treatment, but you needed continuing medication. To be able to do that by way of a telehealth consultation, where you get the prescription done, and it would also provide the opportunity to just check in and see if there was anything else going, worked really, really well. But that's a real human decision which has to be made. Where does this type of technology really work? That was in the cancer framework. In the hospital in Cobar, we sat through a telehealth physiotherapy consultation where the patient had just had a knee replacement, and from Dubbo, they could actually measure how much flexion extension he was getting. So it had that degree of accuracy, but there was none of the hands-on physiotherapy that might be needed to continue with the treatment, because some physiotherapy is continued. They could give this you as a farmer a series of exercises, and they could see whether he was doing them properly, but they needed a nurse in the room to try to further those out. So I don't see it as being legislative. I really do see it as being clinical experience. Now, if it's clinical experience, you go back to that very first point that I made, and that is, how do you get your clinical experience through a computer? You actually don't. The computer in that sense should really be a tool. And as you were talking about the melanoma situation, I was thinking of a friend who literally thought he was going to die. He was so sick. And he eventually got to the specialist. All his blood tests came back lung cancer. And the doctor said, they're the blood tests. He said, I don't think it is. I think it's this other condition called COPS, C-O-P-S. The trouble was, the only way you would know was by the treatment of steroids. If the steroids improved the condition, the clinical diagnosis was correct. And that's where my concern is about siloing decision-making and experience into a technological field.
Thank you very much for that. I think that's a really nuanced answer. Before I hand back to Ms. Fanway, I'm going to give Peter 1 minute to answer a difficult question. A theme from a number of the questions has been, if you increase accountability, will that just add extra cost? Will that add extra time and so on? Is that basically the price that we have to pay for better accountability?
I nearly talked to myself. I think there's always a balance between the formality of accountability processes and making them real and sufficiently agile that they will actually be used in the diversity of organisations that need to undertake them. So I am a great skeptic of episodic consultant-led impact assessments, because they are point of time, they don't adequately bring feedback loops into the consideration, they don't adapt as and when the product adapts and pivots. So I think there is a need for properly scalable, agile accountability systems, and a great danger of over-engineering such that the accountability system is really only suitable for use in highly engineered and structured organisations rather than the range of work environments where accountability is required.
Thanks, Peter. Back to you, Mfanwi.
I knew the time would fly, but thank you very much to all of our panel for sharing their time and insights with us. And while I've got this platform, thank you to everyone at the Human Rights Commission, my fellow expert reference group members, and everyone who contributed to this groundbreaking project. I'm really looking forward to the many ways in which we can work together to make this a reality for the benefit of individuals, shareholders, employee organisations, and our society as a whole. Thank you so much for all of your time today.
Thank you.
Thank you.
Thank you.
Stay safe.